The UK is undergoing a huge overhaul and consolidation of its consumer rights legislation. Part of the new legislation is expected to come into force by June 2014, but businesses will need to start planning how to comply now. There are lots of changes that businesses, in particular digital businesses, should be aware of.
Well, our consumer law has long been criticised for being complex, ambiguous and out of date, especially in respect to technological developments. The EU has also made revisions to the European Consumer Protection Law, which will also need to be applied in the UK. Existing legislation will need to be consolidated, making it clearer and easier for businesses and consumers to navigate. This is going to be much better than having to grapple with the current patchwork of legislation. The new legislation will cover the rights and remedies of consumers in relation to the supply of goods, digital content and services, and will cover on-premises, off-premises and distance contracts. Business-to-business contracts and consumer-to-consumer contracts will not be affected by the changing legislation.
The inclusion of digital content resolves a grey area under current UK legislation. Digital content is defined as data which is produced and supplied in digital form, and this would include software which is downloaded or provided on a disk. The new rights would cover paid-for content and content provided free of charge with paid-for goods and services or other digital content. For example, an app which is downloaded free of charge but which provides for in-app purchases would also be covered.
There will be implied terms in contracts with the consumers that goods and digital content are fit for purpose and services are provided with reasonable care and skill.
Businesses will need to provide certain pre-contractual information about the goods being sold, the identity of the trader, the price and other charges which may be applied, and contractual terms which may apply to the sale.
This information must be made available before the transaction and in a clear and transparent way. A store may wish to include this information at the till point, for example on an A4 poster.
In addition to the requirement to provide information, for online sales it must be made clear to the consumer at the point of sale that they're placing the order and that payment will be taken by the trader. Failure to provide the relevant information in the appropriate manner or to ensure that the buy button is appropriately labelled could mean that the consumer is not bound by the contract or order.
Consumers will have 30 days to reject faulty goods and receive a full refund, or insist that the goods are repaired or replaced.
There are exceptions to this right to the rejection. For example, perishable goods would not be subject to the 30-day period. For online purchases, subject to certain exceptions, the consumer's right to cancel the purchased services, goods and/or digital content has been extended from 7 to 14 days. One exception to this is digital content which downloads automatically at the time of purchase. Provided the consumer expressly acknowledges at the time of purchase that the content will be automatically downloaded and that their right to cancellation will be lost on supply, then they will have no right to request that this purchase be cancelled.
Businesses are advised to start planning for these changes by reviewing their terms, conditions and their policies, and where sales are made online, reviewing their sales journey process to make sure they're compliant with the new legislation. This applies equally to online stores as well as those with a physical presence.